since we're getting into the weeds of policies, contract language, and the nuances that can essentially make or break a claim for somebody, I think we would be doing people a disservice to not also address the group policies that they may be receiving from an employer, some of which they can't say no to.
Mm-hmm.
And this can also limit their ability to get higher levels of individual coverage, association coverage, which they'll get 20 offers in the mail. Um, and really, what, again, if someone's going to go on claim, so on and so forth, big differences amongst that group provided, employer provided coverage, association based coverages, and individual disability insurance that you purchase independently on your own.
So I always refer to this as a two pitcher coffee conversation because it's a big topic. The beauty of an individual disability policy, the individual disability insurance policy, is that you own it. As long as you continue to pay premiums, that policy follows you throughout the duration of the contract period, right? Even if an insurance company exits the market and stops selling disability or is bought out by another company, it's the definitions in that policy. The policy is still in effect. The policy is still in play for benefits. The definitions matter, and getting the best definitions is very important. When we talk about we'll split this up to the employer-provided group long-term disability policies and talk about association. Employer-provided policies, we're referred to as LTD policies, long-term disability policies, are owned by the employer. The insured doesn't own that coverage. They are tethered to it by their employment. So if I leave my hospital group, I lose that coverage unless there's some sort of portability language in there. So that's the first point. It doesn't follow you as your career and life changes. It's tethered to the employer. Point two, and I think one of the most important points, is you, the employee in a large group, are not involved in the selection and negotiation of the terms and conditions of the coverage. So you really have no say in what these policy definitions are. Typically, when we're talking about definitions in group long-term disability plans, they don't have true own occupation coverage. They're marketed and sold as or provided as own occupation coverage, but they typically have a definition that reads something similar to, due to injury or sickness, you have a loss of time or duties and are unable to generate more than 80% of your pre-disability earnings. So you have to show you've got at least a 20% loss of earnings. While it is own occupation in the sense that if you're not working at all in your occupation, the benefit will be paid. They are not true own occupation to the extent that if I am no longer to work as an orthopedic surgeon due to a disability, but I pursue some other career path, those earnings fall under the return to work incentive. And it's either a proportionate loss analysis where they look at the percentage loss similar to a residual disability claim that we were just talking about, or they'll look at your benefit and reduce it by 50% of your current monthly earnings from your new work activity. Another issue we commonly hear is that, or see, is that the policy definition of what the monthly benefit is will say 60% of your covered monthly earnings to a maximum $10,000 a month benefit. Well, the first question is, what are covered monthly earnings? Many of these policies will exclude commissions, bonus, extra compensation. So I've had cases where a doctor is making $250,000, $300,000 a year. Their base compensation is X. Their bonus / whatever additional comp is equal to or a little less than, but it could be a couple $100,000. That income is not considered in the calculation of what the current monthly benefit is. It's only that, let's say it's $100,000. So now if they thought they had $10,000 a month in coverage, based on the current monthly analysis, they've only got $6,000 a month in coverage. Mm-hmm. Another issue we've seen is that often some of these policies will say the benefit is predicated on the premiums paid by the employer. So even though it may say $10,000 or $20,000 a month as the maximum benefit, and your covered monthly earnings would substantiate that the employer hasn't updated or kept up with or not elected to insure you to that amount. So those are often very difficult conversations to have with people and come out of nowhere. Other issues I've seen with, again, the covered monthly earning calculations, again, certain companies will say, we'll employ the first $200,000 of your earnings. Okay, but if you're making $400,000 a year, that $200,000 above your base is not covered, even though it falls in the definition of covered monthly earnings. So I do have cases, and I have had cases where a doctor's making $400,000 a year. The first $200,000 is covered. They now have to show that they are making less than $200,000 a year to qualify for a benefit, even though they've got greater than a 50% loss in earnings. Those are just some examples of covered monthly earning issues. Taxability. If it's paid with pre-tax dollars, the benefits are taxable. So while you may think you have a $10,000 a month benefit, depending on the jurisdiction you're in, if you have federal, state, and city, local taxes, that $10,000 a month benefit can cut back to, 35%. So it's $6,500. These policies also have other deductions for deductible sources of income. Typically, we see that with the form of Social Security, workman's comp, pension benefits that they have from the employer. So again, if you're a high-producing doctor that goes out on disability and you've got a long-term disability plan that is subject to these offsets, it's further chipping away at these benefits. And I had a case where a client walked in thinking they had a $10,000 a month benefit. They didn't have the ability to work in some other capacity, so they were eligible for Social Security disability, and the benefit was taxable. After Social Security disability and the taxability of the benefit, they went from a $10,000 a month benefit to a benefit that was under $5,000 a month. In their mind, they thought they would be stacking the additional $2,500 in Social Security. So there's a lot of nuance here that misleads doctors and other insurers to believe that this is something that's truly helping them, or providing the benefit that an individual disability policy would provide. Another issue that I often see is, and I'm seeing it in certain policies, is a mandatory return to work or vocational rehab, where even though it's own occupation in that broad umbrella sense, they have to avail themselves to training, interviewing, and pursuing other careers, even though it's own occupation. So we're seeing that in some poorly worded policies.
And in group policies as well, they must apply for Social Security disability benefits. So
Even if they're not eligible,
right,
unless they're actively working and can show that they don't meet the loss threshold under Social Security, these companies will compel you to apply for Social Security and go all the way through the claims process through the administrative law judge hearing. It significantly affects coverage. We've seen long-term disability policies that also have other exclusionary language in it. With they'll have a 24-month own occupation definition. So for the first 24 months, unable to perform the material substantial duties of your occupation and a 20% loss of earnings, and then transition after 24 months to any gainful occupation. And if the policy may have a formula in there that defines what the definition of any gainful occupation is, if it doesn't, if you can work doing anything, they're going to terminate the claim. We've seen other situations where, again, people walk in and they don't understand that these policies are also governed by ERISA. And ERISA is it's a federal statute that governs employee benefit packages, and disability falls into it. Long-term disability falls into it. The statute sets in place an administrative claims procedure, but also modifies the burden of proof placed on the insurance companies. So I'm going to spare you a detailed analysis of ERISA, but what's important for your clients to understand and when watching this is that with ERISA, the insurance company, if they deny a claim or terminate a claim, you are required to file an administrative appeal within 180 days of the termination letter. If you do not file that appeal, you are not able to pursue the claim any further. It's like blowing a statute of limitations. Once the appeal is filed, the insurance company then gets to review the information in its separate appeals department. They either come back and accept liability, they issue the back benefit and you move forward with your claim. But if they choose to uphold the claim determination, at that point, and only at that point, can you move forward with filing suit in federal court. And this is where we'll get into a long legal discussion, I'll spare you, but in federal court, it is not a traditional litigated matter where the court is full discovery, we're deposing witnesses, we're sending out interrogatories, requests for production. It is limited to the administrative record. All the information that you submitted, all the information the company reviewed and its opinions and what was relied on in the claim determination. And the court then applies a different standard than what you would see in a traditional breach of contract lawsuit. The other issue is that, there are no extra contractual damages. When we talk about litigating a bad faith claim on an individual disability insurance matter, in those situations, you can pursue extra contractual, meaning damage that go above and beyond what the company owed you. With ERISA, the worst thing that happens is the company just puts you back on claim.